Hello and welcome. This media recording accompanies the course Political Science 4501 and 5501, International Law, taught by Dr. Greg Dixon of the University of West Georgia's Department of Political Science and Planning. This media recording and all course materials are copyright 2014 by Gregory C. Dixon, and all rights are reserved. Students, staff, and faculty of the University of West Georgia have permission to copy, transfer, or otherwise use these recordings for nonprofit educational purposes. This is the first introductory lecture to a course on international law. The course is designed to provide essentially a survey of international law and its principles. It is a graduate, undergraduate, mixed course, so the lectures are primarily oriented towards the junior and senior level of undergraduates. The graduate students in the course are doing significant additional readings. If you're watching this video or any of the other videos related to this class on YouTube, there are a number of readings for the course that go along. This is designed to supplement and to provide context for those readings. The primary reading that is the foundation of this course is Malcolm Shaw's text, International Law, by Cambridge University Press. This first lecture is basically context. It's split into two media recordings, part one and part two. The context here is to put international law into the study of international relations. So these first two lectures are going to introduce the concept of international law, to discuss how international law is different from domestic law, and to talk about where international law fits in the discussion of international relations. So in our academic discipline, where do we place international law? And one of the big things that we're going to get in these first two lectures is a sense of the controversy and challenge that comes from our discussions of international law. One of the things about international relations is that it is a very diverse discipline. There are many different ways of looking at the same concepts, and international law is going to be one of those concepts about which we have a great many different ways of thinking and sort of theoretical frameworks for applying. So these first lectures are just to kind of get everything going, to give context. To start off with, this is a course in international relations. It is a political science course focused on the subfield of IR and looking at, in general, the study of relations between actors that cross national borders. This is a very diverse subfield. We talk about a lot of different stuff. When we talk about actors, this could be individual persons, it can be multinational corporations, it can be non-governmental organizations, intergovernmental organizations, nation states, pretty much any organizational form that humans have created. If it interacts across national borders, we consider that to be this part of the study of IR. So you can imagine that this pretty much includes almost everything there is to include in the modern globalized world of today. IR thus includes a lot of different issue areas and includes an enormous array of diverse perspectives. So there's no clear agreement on how to study relations between actors across borders. And this is going to be somewhat frustrating, particularly for anybody coming from the hard sciences like chemistry or physics, where you study things where there's a mathematical equation or a series of relationships, and there is some form of the equal sign at the end, and then you get an answer. In IR, you can have 20 different valid answers to the same basic question. Part of what makes the discipline fun is this diversity. It's very interesting to see these different perspectives. But in the modern era where students have been trained, particularly in K-12, to think of the entire universe as being amenable to an A, B, C, D answer or a formulaic answer, IR is not like that. And this course on international law, we will repeatedly come across circumstances where really, truly expert individuals disagree vehemently with each other about what exactly something means and how it should be interpreted, even in areas that have been around as international law for hundreds of years. International law is one way of solving collective problems internationally. It fits into and is bound up in a whole series of other international actors and structures. And one of the things we're going to talk about as this course goes on is how we fit international law into all of these other understandings. It is a loose set of rules governing a wide range of behaviors. We're going to talk about how international law is different from domestic law in a little bit, but one of the biggest things that we want to remember is that international law has, generally speaking, a much looser framework than domestic law does because of the lack of a central enforcer. So international law, when we talk about a loose set of rules, that doesn't mean that international laws may not be specific. It just means that in comparison to domestic law, the ability of those legal systems to enforce themselves and to actually function in the way that we expect domestic law to is highly varied. So international law, much looser than domestic law in most cases. International law has expanded significantly in the 20th century. One of the big differences between the 20th century, particularly the post-World War II period, and prior centuries, is that we are interconnected in a way that we have not been in the past. In fact, many, many ways that we have not been in the past. Even in the late 1800s, where the world was arguably about as globalized as it is today, the speed of information and the penetration of that large-scale globalization at the local level was not as powerful as what we experience today. I would argue that economically and in terms of movement of persons and goods, you can make the case that the colonial system of the late 1800s was as highly globalized as the world is today. But I would make the case that today, in a world of the internet and Twitter and social media and whatever new things are being invented as I'm recording this, that the contemporary world, while it has a material globalization that's on par with the colonial era, is significantly different in terms of its social, cultural, and information-oriented globalization. I would also argue that the globalization of today is, at least in its potential, this is another one of those areas that's highly controversial in IR, but at least in the potential today, the contemporary globalization lacks the material coercion of the colonial era. A lot of other negative aspects of it, but the material coercion, where we literally put armies of thousands upon thousands of people in your territory and kill you, is something that we do not see as we did in the colonial era. But again, this is something that's also highly contentious. World systems theorists would argue that things are highly coercive today. But in the 20th century, one of the ways that we've tried to resolve the issues of previous periods in history is to create international law so that there are clearly codified rules of how to behave across borders, rules that states agree upon. The other thing that we get is, because information can be shared so readily, and because globalization begins to touch many more people's lives, the scope for international agreements has grown. So what's interesting here is that we've seen international law expand significantly, and the pace at which it expands appears to be continuing on a process of acceleration as we move into the 21st century. So early in the 20th century, there were some expansions of international law. We see big expansions coming in the post-World War II period, and today we see more and more areas in which international law seems to be required to solve collective problems. There are basically two broad types of international law. The first is public international law. And this is the international law that governs relations between states. So when the United States and the United Kingdom, the US and Great Britain, are discussing a treaty, or whether countries are coming together to discuss modifications to a treaty like the North Atlantic Treaty, that is the foundation of the North Atlantic Treaty Organization, which is NATO. When countries are coming together in those kind of discussions, that's public international law, relations between states. Private international law covers areas of conflict and relations between national laws and international actors. This is a very broad and constantly changing and transforming area of international law, but private international law is by far the larger in terms of the number of interaction it affects, although you almost never, unless you were in international business or if you're here at West Georgia, an international economic affairs major, you very rarely hear private international law discussed. It's usually public international law that gets all the press. Public international law is, in fact, almost all of what you probably had as an idea of international law before you came into this class. It has the longest formal history, although private international law has existed as long as there have been political entities to have conflicts with individuals who have to operate in them. The formal history, in the Western tradition in particular, of how law works globally, it's public international law. It goes back to the Age of Kings, signing legally binding treaties with each other, looking to the Pope for validation. If we break the treaty, God will be mad at us. Worst case scenario, you could be excommunicated, and in the old days that meant that basically you were going to hell. So these things were important even back into the medieval period. Most international relations scholarship in international law looks at public international law, and in particular, generally, how it fits into either an institutional framework, such as the work that I do in World Trade Organization disputes, or in the transmission of norms and values in the international system, such as work that deals with human rights and other types of sort of more individually oriented issues. Most of what we're going to talk about in this class is public international law. The focus of most of what we're going to be looking at is this area, because it is the area that has the most scholarship on it. Now, if I had taught this class 5 years ago, the entire course would have been on public international law, because that's basically how courses were. There have been a lot of really interesting developments, and honestly, I've found a lot of really interesting stuff out there dealing with some of these questions of private international law. And so we're going to talk about, towards the latter quarter of the course, some private international law issues and solutions to various problems. Private international law covers areas dealing with the clash of international and domestic laws. This is one of those things that's kind of interesting because it's hugely diverse. This has a long history, but IR has kind of tended to ignore it. It's not really something that international relations scholars liked, partly because it's really hard to get data. It's really hard to actually find things to analyze in any kind of a quantitative way. And in a qualitative way, the problem is there's so much and it's so diverse, it's hard to write works that can be generalized. But what we talk about when we mean private international law is, for instance, a multinational corporation that has a headquarters in the United States. Let's say they're headquartered in Dallas, Texas, and they have operations in Brazil and Nigeria and Indonesia and Australia. Well, private international law is what's going to really be a focus for that company, because it has to operate in multiple jurisdictions. Most likely its corporate structure is going to be set up in such a way that it's going to use jurisdictions that it doesn't actually do anything in, but that are useful for tax purposes or for the facilitation of money transfers between subsidiaries. And so you could, with just one company operating in 4 or 5 countries, have as many as 10 legal jurisdictions that you might have to be thinking about. So how, for instance, do you enforce a contract? If a Dallas-based company signs a contract with a company in Indonesia and they disagree over the contract terms, who decides how to enforce the contract and who ultimately enforces the contract? Do you use American law or Indonesian law? If the company is a big, powerful multinational corporation and their dispute is with a small Indonesian company, how does that Indonesian company guarantee fairness? It might be that they want to use local courts to mitigate against the power of the big company. The big company may want to use American courts because it'll disadvantage the other company involved. There are a whole series of ways of solving these kinds of problems. There are lots and lots of issues with this, and I've given you one example. There are thousands of these things. It could be not a company having a disagreement with another company. It could be a company having a disagreement with a country. Argentina issued a ton of bonds in the late 90s that were explicitly denominated in dollars because Argentina at that time pegged its currency to the dollar. And in those contracts, in order to get a lower interest rate, because interest rates basically are dependent on risk, to reduce the risk for investors and get a lower interest rate, Argentina agreed that the governing law for any disputes would be that of the state of New York in the United States. And this has been a problem for Argentina because Argentina defaulted on those debts and imposed on borrowers a settlement. They essentially said, take this or leave it. And that was pennies on the dollar. Well, there are a handful of investors who held those Argentinian bonds said, well, we're not taking your deal because it's New York's law that applies. We're going to sue you in New York to get all of our money back. And basically what then happened was they had to go to New York to go to court. Argentina has said, well, we're not going to really be involved in this. We're going to just kind of go with the deal that we've got. Most people took our deal, and we're not going to deal with these people. But the investors can use New York law to seek settlement and damages from Argentina, and they can seek to block Argentina from doing any kind of transactions in the United States that pay money to the people who took the deal at the expense of the people who didn't. So you get this really weird situation in which the country of Argentina has to fight private investors in a New York court because of the structure of the contract. That's private international law, and it's a really complicated area, but it has a huge practical impact. And you can see why it's international business and scholars who focus on business issues that have really been the ones who are most interested in private international law. You get lawyers who are also interested in it because all the people fighting back and forth on these things are ultimately going to be business lawyers. And the practical impact in a globalized economy is huge because millions of companies in the world have to deal with these basic questions. How do we enforce our contracts? And one of the things when we talk about international economic law, we will talk about private international law in a big way. So the last quarter or so of the course, when we're looking at these sorts of questions, one of the things that we'll talk about is this international economic law and sort of how that fits private international law. The interesting thing now is that there's a growing part of international law, private international law, that is looking at legal agreements between private parties. Businesses in different countries are increasingly using third-party countries' laws for contracts. Let's say that you are in Indonesia and you want to do business with a country in Africa. Let's just say Uganda. So you're a business in Indonesia. You want to start selling your goods in Uganda. You go to local Ugandan companies. The problem is you're not real sure about Ugandan law. And those companies in Uganda, they're not really sure about Indonesian law. And so what you get is companies see a big risk dealing with each other. And so you might say, to make this easier on everybody, let's use the governing law of the United States, or the governing law of Great Britain, or the governing law. It doesn't have to be the sort of big countries like that. It might be any place that has a reputation for good rule of law. You might say Australia, wherever. Depending regionally on where these companies are, they may pick some third country and say, what we're going to do is we're going to write these these contracts in such a way that if we have a dispute, we can go to this third party country's legal system and seek redress. These are still relatively rare in dealing with sort of south-south contract development, but we see this increasingly when we're looking at countries that are doing business in the north and south. They look for third-party countries because a lot of times you're not really going to necessarily trust the rule of law in a country that doesn't have a good reputation for it. Dispute settlement outside of domestic legal frameworks also happens. You have organizations that exist. One of the biggest is the International Chamber of Commerce, that actually has an arbitration system that has dealt with tens of thousands of cases in which companies have signed contracts with each other, and rather than use the domestic legal system of any country in the world, they go to these outside systems that are run by, in the case of the International Chamber of Commerce, a non-governmental organization to ultimately resolve the dispute. So there's lots of different answers to these sorts of problems that potentially arise. And in international law, one of the challenges is, how do you deal with this enormous variety that's out there? Well, one of the key distinctions, one of the things you absolutely have to keep in your mind, especially if you are someone who wants to go to law school and is interested in these kind of things, is that international law is not like domestic law. International law is very different, and the distinction is absolutely critical for understanding how international law works.